Good morning. It is Saturday, February the 12th, and this is The Drill. Welcome to all the butchers, bakers, and candlestick makers out there. I'm Ron, your host, and the only true conservative in the United States today. So today, after the daily declaration for spiritual warfare, the Pledge of Allegiance, and the Star-Spangled Banner, we will have hogs and rights, no free lunch, and see you in court. All that and more when I come back. Thank you. Ineffable Creator, who out of the treasures of thy wisdom has appointed 3 hierarchies of angels and set them in admirable order high above the heavens, and has disposed the divers portion of the universe in such marvelous array. Thou who art called the true source of light and supereminent principle of wisdom, be pleased to cast a beam of thy radiance upon the darkness of my mind and dispel me from the double darkness of sin and ignorance in which I have been born. Thou who makest eloquent the tongues of little children, fashion my words and pour upon my lips the grace of thy benediction. Grant me penetration to understand, capacity to retain, method and facility in study, subtlety in interpretation, and abundant grace of expression. Order the beginning, direct the progress, and perfect the achievement of my work. Thou who art true God and man, and livest and reignest forever and ever. Amen. Thank you. And now for the daily declaration for spiritual warfare for February the 12th. Ungodly covenants made by your ancestors are broken. If you violate my covenant and go and serve other gods and bow down to them, my anger will burn against you, and you will quickly perish from the good land I have given you. But if you do not follow other gods to your own harm, then I will let you live in this place in the land I gave your forefathers forever and ever. I've laid a sure foundation, and if you rely on my precious cornerstone and make my justice your measuring line and righteousness your plumb line, then I will disannul all ungodly covenants your ancestors made with idols, demons, false religious, or ungodly organizations in the name of my Son Jesus. I will take hold of your hand and will keep you and make you to be a covenant for the people and a light for unbelievers. Exodus chapter 23, verses 31 through 33, Matthew chapter 5, verse 33, Isaiah chapter 42, verse 6. Prayer declaration. I break and disannul all ungodly covenants, oaths, and pledges I have made with my lips in the name of Jesus. I break and disannul all covenants with death and hell made by my ancestors in the name of Jesus. I command all demons that claim any legal right to my life through covenants to come out in the name of Jesus. And that was the declaration for the daily declaration for spiritual warfare for February the 12th. Thank you. Who is the true conservative? He is the person that has the courage of his convictions and is confident in what he knows. He is the person that understands that cultural conservatism is more important than political conservatism. He is not selfish, but minds his own business. He acts like an adult. He is patriotic and uses common sense. He expresses what he knows and does so with certainty. He makes judgments, refuses to speculate, speaks clearly and definitively, and is not afraid to say no. He's open-minded, asking why rather than why not. He is consistent, credible, and influential, not ashamed of his existence, unafraid to learn or correct his mistakes. He is a normal American, and he's better than the socialist. He's a better friend, father, brother, family member, and a better person, period. You have to know that. If you don't know with every fiber of your being that being a true conservative is best, then you're wasting your time. Thank you. And now there's no free lunch. Capitalists are motivated not chiefly by the desire to consume wealth or indulge their appetites, but by the freedom and power to consummate their entrepreneurial ideas. George Gilder. Anyone who spent any time with the serial entrepreneur knows this to be true, that while the profit motive and quality of life considerations drive ambition to a degree, they can't hold a candle to the innate desire to act, produce, create, and grow. The delivery and execution of an idea is at the heart of successful entrepreneurship, and profits merely follow. Somewhere in all of this will be consumption, yet fundamentally the driver of entrepreneurship is always the combination of the vision, dream, and passion of the entrepreneur. And that was, there's no free lunch. Thank you. And now, see you in court. At the end of his long career, Supreme Court Justice William Brennan was asked which of his opinions he regarded as his most important. Brennan had served on the High Court for 35 years, masterminding its liberal majority until the mid-1980s, and then leading the opposition to its more conservative decisions. He might very understandably have been expected to hesitate. He didn't. He replied straight away, Goldberg v. Kelly. It might seem strange that a case few non-lawyers have ever heard of should be rated by its author as outweighing his opinions outlawing school prayer, requiring states to provide indigent defendants with free lawyers, or smashing the ancient political power of farmers by mandating that all state Senate districts contain roughly the same number of people. But Brennan was quite right. The Goldberg in Goldberg v. Kelly was Jack R. Goldberg, New York City's Commissioner of Social Services. Since the 1930s, New York had prided itself on its generous municipal welfare state. It's not clear that the city was ever really able to afford these benefits, but by the mid-1960s, the financial undergirding of the municipal welfare state was visibly crumbling. Middle-income taxpayers left for the suburbs. The city paid its bills by ever more desperate financial jiggery-pokery. Because benefit cuts were politically unpalatable to the liberal city government, city officials responded to the gathering crisis with a series of crackdowns on welfare fraud. This outraged the city's litigious political left, who mounted a suit in the name of 20 of the most sympathetic individuals purged from the rolls. Under prevailing law, the plaintiffs would not seem to have had much of a case. There is no constitutional right to welfare, much less a right to receive welfare fraudulently. The plaintiffs conceded that New York might be entitled to deny welfare to Juan de Jesus, one of the lead plaintiffs in Goldberg, if he were, as the city maintained, a drug addict. What they denied was that the city was entitled to decide for itself whether de Jesus was an addict. It was this latter contention that Justice Brennan inscribed into the American law. The Fifth Amendment to the Constitution says that no American can be deprived of life, liberty, or property without due process of law. Before stopping de Jesus' check, Brennan decreed, the city of New York owed him a formal evidentiary hearing where he could argue his side of the case. That may not sound like a revolutionary statement, but it was. It meant that every individual instance of welfare fraud would have to be litigated, with appeals available to the federal judiciary at immense cost in both money and time. Goldberg was a decisive milestone en route to New York City's 1975 financial collapse. William Brennan, like Mao Zedong, was one of those unusual men who get more radical as they age. In his early years on the Supreme Court, he distinguished himself by devising ingeniously plausible legal arguments for liberal policies. But as the liberal majority on the court expanded in the middle of the 60s, his opinions simultaneously became bolder and less convincing. He took less trouble to wrap his personal preferences in the tissue and ribbon of constitutional law. In Goldberg, Brennan faced a conundrum. He wanted to grant the legal protections of property to welfare payments, which he himself acknowledged were not property. His solution, instead of the old stark binary distinction between property and not property, Brennan proposed a vast intermediate range of property interests that deserve some blurry intermediate to be figured out later measure of legal protection. This was typical of Brennan's jurisprudence. For him, the law was never a clear-cut set of rules by which citizens could ascertain their rights and officials govern their conduct. It was an unpredictable and continually shifting set of standards. When Brennan was new to the court, Americans delighted in sonorous invocations of the majesty of the law. Think of the great speech Robert Bolt gave Thomas More in his 1962 play, A Man for All Seasons. Almost nobody talks like that anymore. The sacredness of the law was a pretty illusion blown to the winds by chilly power, the zeal of Brennan's liberal majority to have its own way, regardless of precedent or logic. In person, Brennan was the gentlest, mildest, and most considerate of men. Many of the ideals he manipulated the law to uphold were admirable, but the ideal of ideals that ought to have been guided his judging, that no result is admirable enough to justify illegitimate methods, that was as alien to the mind of this kindly, unscrupulous man as the uncharitable act or an uncivil word. Back in a minute. Thank you. America has always been a legalistic society, but it has not always found it necessary to settle every dispute in court. In mid-century, actually, Americans seem to be taking unusual pains to avoid submitting problems to the courts. The law is slow, judges are inexpert. For an era interested in comprehensive solutions to large-scale social problems, law and lawyers seem inadequate. The judges themselves felt their inadequacy. In their articles and books, the leading jurists of the era declared their willingness to defer in almost all things to the judgment of legislators and their bureaucratic deputies. It certainly does not accord with the underlying presumptions of popular government, Judge Learned Hand said in his famous lectures on the Bill of Rights, to vest in a chamber unaccountable to anyone but itself the power to suppress social experiments which it does not approve. What changed the minds, first of the jurists and of a larger society, were the school desegregation decisions of 1954. Brown v. Board of Education and Balling v. Sharp, decided on the same day. With very flimsy legal justification, Chief Justice Earl Warren's own law clerk described the court's reasoning as gibberish. The justices boldly overturned a social institution supported, to their shame, by the majority population of 17 states. It was by no means certain that the court would prevail over the opposition of the Southern governors and the Southern Bloc in Congress, but it did prevail, and that success inspired the bold self-confidence that was such a striking feature of American courts in the 1960s and of American lawyers in the 60s and 70s. Lawyers then were like doctors in the 2 decades after the discovery of antibiotics. There was nothing they could not do, no problem they could not solve. Whatever ailed the country, more law was the answer. When Justice Brennan wrote Goldberg v. Kelly, he did not pretend to know better than the Social Service Commissioner how an effective welfare program should be run. What he believed, however, was that the appropriate place in which to decide the matter was a courtroom, and that the right way to decide it was as a question of justiciable rights in an adversarial proceeding under the supervision of a judge. Indeed, that was the right place and the right way to decide almost everything, such as how to run the schools In January 75, the Supreme Court ruled that public schools pupils suspended for disciplinary reasons also had a right to a hearing. Young people do not shed their rights at the schoolroom door, wrote Justice Byron White in Goss v. Lopez. The Constitution of Ohio guaranteed its residents an education, and that right could not be taken away, absent fundamentally fair procedures. The Supreme Court had laid down what might be called the Bad Kids Magna Carta, a set of rights that would grease the public school's slide into ungovernability, such as who qualifies to practice medicine. When Charlotte Horowitz flunked out of the University of Missouri Medical School, she decided that her constitutional rights had been violated and sued. Although Horowitz had attended class irregularly and failed her examinations, she believed that she was entitled to a miniature trial before the school could legally bounce her. The Eighth Circuit Court of Appeals agreed, and so did 4 of the 9 justices of the Supreme Court. Only one vote prevented Board of Curators versus Horowitz from becoming the dumb doctor's Magna Carta, such as which foreign nationals might be dangerous to the United States. After a spate of pro-Khomeini demonstrations by Iranian students in the United States during the 1979 hostage crisis, the Immigration and Naturalization Service decided to look into the status of the demonstrators. It found that fully 10% of them were in the United States unlawfully. But in December 1979, U.S. District Judge Joyce Green ruled that the INS investigation was impermissibly arbitrary and must halt. There is, at best, a dubious relationship between the presence of Iranian students in this country, whether legally or otherwise, and the safety and freedom of the hostages in the U.S. Embassy in Tehran. Back in a minute. Thank you. Such as, what equipment could be used in athletic competitions? Disabled would-be marathoners obtained a judgment in 1979 that the New York City's Roadrunners Club must drop its rules forbidding racers to use wheelchairs. The club argued that it ought to be allowed to set its own rules for its own events, and it warned that on some of the steep downhill portions of the race, speeding wheelchairs could pose a hazard to other runners. The court waved away both arguments. Like the mix of 2 volatile chemicals, the due process revolution mingled with the ambitious new environmental protection laws of the 1970s to ensure that virtually every road, dam, airport, sewage plant, harbor, or levee built by any federal, state, or local agency, and a big chunk of private enterprise activity as well, could be second-guessed by a court. Was an environmental impact statement filed? Was it detailed enough? Had the appropriate federal agency reviewed it in a manner required by the latest federal regulations? If the law could save the environment, protect students from intolerant teachers, and safeguard the rights of wheelchair-bound athletes, surely it could do something for victims of defective lawnmowers and industrial pollution as well. Multi-million-dollar mass tort actions are a phenomenon in the 80s and 90s, but it was in the 1970s that the legal foundations of the supersuits were laid. The Supreme Court of California ruled in 1978 that in product liability cases, the burden of proof belonged to the defendant. If your machine injured a user, then it was up to you to prove that the machine was not unsafe. The rules governing class actions were relaxed by state courts, New Jersey and California typically leading the way. Punitive damage awards skyrocketed. Theodore Olson of Gibson, Dunn, and Crutcher found that the California record on punitive damages upheld on appeal rose from $10,000 in the period between 1922 and 1959 to $250,000 in the 60s, $740,000 in the 70s, and $3 million in 1986. The obstacles to contingency fees, the devices that would lead to the truly colossal payouts of the late 80s and 90s, were bulldozed one by one. The old progressive regulators were systemizers. They believed in institutions and rules rather than individual hard cases. Early in his professorship at Harvard, observes a study of Jane Landis, often thought of as the single most intellectually brilliant of the young lawyers who made the New Deal. Landis had become fascinated by the obvious gap between legislation and administration that characterized modern American government. Studying the lack of connection, he tried to puzzle out the resulting paradox, so common in regulation, between admirable intentions of legislation and perverse results of administration. What was needed was a way of institutionalizing the linkages between ends and means, between legislation and administration. Tort law, as it evolved through the 1970s, was determinedly unsystematic. It did not worry about inconsistent or even counterproductive results. It cared not about rules, but about the plight of one particular individual demanding his rights. The progressives had glorified science. The new tort law was often willfully anti-scientific, allowing the testimony of even the most eccentric and discredited experts to be presented to the jury as if it were just one opinion among many. One of the first great mass tort cases of the 1980s involved a morning sickness drug called Bendectin. Juries awarded women who used Bendectin and then gave birth to deformed children verdicts of up to $95 million, despite the near unanimous scientific consensus that Bendectin did not cause the injuries. The progressives had reposed their trust in the dispassionate, qualified civil service professionals. The new tort law put the work of defending society into the hands of freelance lawyers skilled at emotionally appealing to juries, motivated by personal gain. Back in a minute. Thank you. The due process revolution in the public sector and the tort revolution in the private sector have been launched to protect citizens against the potential arbitrariness of bureaucrats and the selfishness of corporations. But asking judges to second-guess bureaucrats and the businessmen seldom yielded the fairness that Justice Brennan had promised. Quite the opposite. The harder judges tried to mete out equal justice to all, the more capricious and whimsical the legal system looked. Telling a welfare agency or housing authority that it must administer due process before cutting off a fraudster or evicting a hoodlum raises more questions than it resolves. What sort of process exactly is due? Might some bureaucratic decisions require more process and others less? There is an argument, after all, that we want to make it easier to evict a bad tenant from public housing, where he might threaten the safety of other tenants, than to cut off his welfare check, which merely wastes money. On the other hand, there's an equally good argument that we might want to make it harder to evict a tenant, this is the man's home we are talking about after all, than to stop his check. The deeper the courts plunged into this thicket of confusion, the more unsatisfactory, even ludicrous the results. And unfortunately, the area of law that they made the worst mess of also happened to be the most politically explosive: religion. American local government has long struggled with the problem of how much aid can and should be given to religious schools. From the 1920s until the mid-60s, federal courts had tended to take a permissive attitude, allowing, for example, states to donate textbooks and provide school transportation. The Warren Court cast aside this easygoing attitude. Richard Nixon scored political points in 1968 by promising to appoint judges who would treat religious schools more indulgently. In 1971, that promise was put to the test in the case of Lemon v. Kurtzman. Lemon challenged the constitutionality of two state programs, one in Rhode Island, which subsidized the salaries of religious school teachers who taught secular subjects, and another in Pennsylvania, which reimbursed religious schools for purchases of instructional materials from the state's public school system. Chief Justice Warren Burger used the case to lay down some principles of law. State aid to religious institutions was permitted, he said, provided it met three conditions. 1, it was provided for a secular purpose. 2, it neither aided nor inhibited religion. And 3, it did not excessively entangle church and state. On that basis, the court struck down both the Rhode Island and Pennsylvania programs. The new rules did not pack anything like the clarity that Warren Burger thought they did. By striking down the Pennsylvania law without explicitly overruling either the court's older, laxer precedents or its newer, stricter ones, the Burger court had blundered its way to the conclusion that the Constitution permitted states to give schools geography textbooks, but not the maps that illustrated them. Worse, the key section of Lemon, the part prohibiting excessive entanglement, simply restated the problem it supposed to solve. How much entanglement is excessive? Only more litigation could provide the answer. The vagueness of the Lemon test ensured that the constitutionality of almost every contact between church and state would henceforward be determined by a judge's seat-of-the-pants determination. The civil status of the religion that illuminates the lives of tens of millions of Americans was plunged into perpetual murk. Not that the judges of 1970s could not be decisive when they really wanted to. The deinstitutionalization of the mentally ill was a public policy on which judges never wavered. The availability of antipsychotic drugs after 1954 prompted some states to test whether the insane could be released under doctor's supervision. The states' motives were mostly economic. The cost of caring for more than 500,000 state mental patients of the mid-1950s was threatening to overwhelm state budgets, especially in those states, New York and California, which tried hardest to treat the mentally ill rather than indifferently warehouse them. Back in a minute. Thank you. Deinstitutionalization was not an entirely wild idea, if carefully put into effect. The new drugs held out hope that many of the insane could be restored to liberty. But the seriously mentally ill cannot simply be released into the community with a jar of pills. To protect the community, they must be carefully monitored by doctors who can have them recommitted if they relapse. Alas, that is just what America's judges decided the Constitution forbade, creating the misery that we have all learned to step over on our sidewalks and to look away from as it searches through trash cans for food. Judges are not all-knowing wise men. They're human beings like anyone else, enthralled to the ideas of their times. If anything, the lawyers chosen for the bench are probably among the most conventionally minded members of the profession, itself notorious for conventionality. And one conventional notion whizzing around in the air of the 1960s and 70s was that insanity was a medically meaningless category that stigmatized people whose only offense was a refusal to conform to the rituals of a corrupt society. Sounds pretty funny when you put it like that, but in the middle 1960s, the refusal to believe in insanity was the very acme of chic. R.D. Laing, a radical British psychoanalyst, achieved an almost Beatles level of celebrity by arguing that schizophrenics were actually reacting rationally to intolerable situations, that indeed they were saner in more ways than the people who had adjusted to a society that could, for instance, build hydrogen bombs and wage war in Vietnam. Michel Foucault made his reputation with a dissertation translated into English as Madness and Civilization in 1965 that argued the very attempt to help the mentally ill was a form of oppression by denying them their human difference. The asylum becomes an instrument of moral uniformity and social denunciation that imposes a social segregation that would guarantee bourgeois morality a universality of fact and permit it to be imposed as a law upon all forms of insanity. The meaninglessness, even the goodness of madness became something of a 1960s literary trope. It inspired the 1966 cult film King of Hearts, in which a British soldier cut off from his unit during one of the battles of the First World War stumbles into a French insane asylum and finds the residents eccentric, yes, but charming, and in the end far less mad than the blood-crazed world around them. Ken Kesey's 1962 novel One Flew Over the Cuckoo's Nest and the movie the same name, which won the Academy Award for Best Picture in 1975, made the same point. The people who run insane asylums are not only crazy, but also dangerous. Of all the psychiatric writers of the 60s, the one who had the most impact on American society was the Hungarian-born libertarian Thomas Szasz, at least if the number of citations and judicial opinions is any guide. In a series of books beginning with The Myth of Mental Illness in 1961, Szasz charged that the concept of mental illness served only to enlarge the power of the state to lock up people who might be troublesome and offensive, but who had broken no laws. Szasz is suggesting that treatment for mental illness be analogized to incarceration for a crime made tremendous sense to a society increasingly inclined to interpret every issue in terms derived from civil rights and civil liberties law. His disdain for the alleged expertise of psychiatrists was given a tremendous boost by a notorious experiment by a Stanford professor of psychology named David Rosenhan, republished in the journal Science in 1973. Rosenhan sent 8 pseudo-patients, among them 3 psychologists, a pediatrician, a psychiatrist, a painter, and a housewife, to gain admission to 12 different hospitals in 5 states on the East and West Coasts. Each pseudo-patient was to come to the hospital administration office complaining that he had been hearing voices. Asked what the voices said, the patient was to say that they were unclear, but seemed to be saying empty, hollow, and thud. Apart from falsifying name, occupation, and employment, the patient was to report his life history truthfully. Immediately upon admission, the patient was to cease simulating any symptoms of abnormality. All 8 patients were diagnosed as schizophrenic. All were admitted to the hospital. They were held for an average of 19 days before being released. Then the experiment was performed in reverse. Rosen Hahn told a major teaching hospital that he would be sending pseudo-patients on their way over the next 3 months. The hospital asked its receiving staff to identify which of the applicants seemed likeliest to be acting. Of the 193 patients who presented themselves over the test period, 23 were considered suspect by at least one psychiatrist. In fact, all 193 were genuine. Rosenhan had sent no pseudo-patients at all. Now, as 2 wise observers put it, while this was scarcely psychiatry's finest hour, it also proved far less than Rosenhan implied that it did. The study shed light on the limitations of hospitals and psychiatrists, but none on the nature or reality of insanity. Rosenhan sent no patients feigning symptoms of heart disease or muscular dystrophy or epilepsy to internists. Would he have concluded, had they been fooled, that this proved the non-existence of these diseases? Back in a minute. Thank you. But if Rosenhan's experiment had dubious scientific meaning, it had large legal implications. In the deferential 1950s, psychiatrists had broad power in most states to commit patients to hospitals against their will. In the 1970s, that power was snatched away. In June 1975, the Supreme Court delivered its ruling in the important case of O'Connor versus Donaldson. The mentally ill could not be detained unless they could be shown to constitute a danger to others or were incapable of living on their own. Potter Stewart's opinion might as well have been scalped from Thomas Saz. May the state fence in the harmless mentally ill solely to save its citizens from exposure to those whose ways are different? One might as well ask, Stewart continued, if the state, to avoid public unease, could incarcerate all who are physically unattractive or socially eccentric. Mere public intolerance or animosity cannot constitutionally justify the deprivation of a person's physical liberty. Who is to say which of the mentally ill are harmless? The Supreme Court settled that question in 1979. Frank Addington, a mental patient, disputed the right of Texas to confine him against his will. Chief Justice Berger decided for the court that the relevant standard for deciding the question ought to be far more stringent than a doctor's opinion alone. The insane also had their due process rights, and unless the state's medical experts could prove to the satisfaction of a court by clear, unequivocal, and convincing evidence that a mental patient represented a danger to society or to himself, he or she could not be detained against his wishes. One reason the court dared go this far was that the state Supreme Courts were going further. Indeed, the Massachusetts, New Hampshire, District of Columbia, Minnesota, New Jersey, and Kentucky courts had imposed on the mental health authorities the same beyond a reasonable doubt standard that prosecutors had to meet for the jailing of a criminal. Cases like Addington's accelerated the emptying out of the state mental hospitals. Between 1955 and 1970, the number of patients in state hospitals declined from 559,000 to 339,000. Between 1970 and 1980, the number of patients fell from 339,000 to 130,000. The figure for 1995 is approximately 70,000. What happened to these people? At first, thanks to the sluggish urban real estate market of the 1970s, they found shelter in deteriorating old buildings, converting them to slum hotels. Let's try that again. They found shelter in deteriorating old buildings converted to slum hotels. They paid the rent, often with the help of a new federal program, the Supplemental Security Income Program created in 1974, which recognized schizophrenia and other severe mental illnesses as disabilities and paid pensions to those suffering from them. This created a very stark set of financial incentives for states. Because the federal government had refused to extend Medicare or Medicaid to mental hospitals in 1965, states had to pay the full cost of treating the mentally ill if they kept patients institutionalized. If they released them to the streets, however, Medicaid would cover their treatments at a nursing home or community health center, and SSI would pay their living expenses. But as the urban housing market warmed up in the 1980s, the old slum hotels were demolished to make way for apartment buildings and condominiums. By then, the new legal standards were ensuring that younger generations of mentally ill people were never institutionalized in the first place. California, which admitted 42,000 people to its mental hospitals in 1970, admitted only 19,000 in 1980. Massachusetts had admitted 13,000 at the beginning of the 70s, but only 6,000 at the end. Obviously disturbed people began to appear on America's streets, pushing stolen supermarket shopping carts filled with their forlorn possessions, their hair grown to their back, their feet bare and scarred, sleeping on sewer grates, cursing passersby or attacking them, sometimes fatally. And when local officials tried to do something for these troubled people, the courts hastily interposed themselves. A landmark 1972 Supreme Court decision declared laws against vagrancy unconstitutional. In December 1973, the court affirmed an appellate decision that had struck down a New York state law prohibiting loitering without apparent reason and under circumstances which justify suspicion that the loiterer may be engaged in a crime. In the 1980s, a federal judge in New York declared begging a constitutional right. Another forbade the town of Morristown, New Jersey, to order an unwashed, foul-smelling man who stared menacingly at single women to leave its library. Individuals like Larry Hogue, the madman of 96th Street, who assaulted women and children and smashed parked cars, and Billy Boggs, the alias of a woman who shrieked obscenities at black men and defecated on street corners, became local celebrities, protected in their right to haunt the streets by the New York Civil Liberties Association. And because this final collapse of the old state mental health system happened to coincide with the controversial first months of the Reagan administration, few local governments were really eager to remove people like Hogue and Boggs. After all, by reimagining the deinstitutionalized mentally ill as merely homeless, the Democrats, who typically controlled city governments, acquired a powerful new weapon with which to rebuke the Republican-controlled federal government for cutting its spending on public housing and rent subsidies. Not all the homeless were mentally ill. Some were drunks or addicts, and others were ex-cons unable to make the transition to conventional life. Some had been thrown out of work in the recessions of 79 to 82 and never managed to clamber back in. Some were mothers who had heard that by arriving at a city shelter with children, they could jump to the head of the queue for subsidized housing. But many, at least 40%, and by the end of the 80s, probably closer to two-thirds, were seriously mentally ill. The best estimates of the number of homeless in the United States ranged between 300,000 and 600,000, or rather fewer than the number of mental patients the country would have if the 1955 number had kept up with the increases in population. Back in a minute. Thank you. It had once been thought society's duty to care for the insane. Even Calvin Coolidge, that famously frugal Yankee, pushed through substantial increases in spending for state mental hospitals as governor of Massachusetts. In the 1970s, in the name of civil liberties, that duty to care was rescinded. Advocates for the homeless insisted that the people they claimed to speak for could be entirely self-reliant, if only society paid their rent for them. They were not sick, they were victims. And so they were, not of a housing shortage, but of an institutional failure, the attempt to stretch law far beyond its rightful limits. And that was See You in Court from the book How We Got Here, the 70s, the decade that, for better or for worse, shaped American society. Thank you. Who is the socialist? He is the man that seeks consensus. He is subjective, petty, and small, taking everything in life personally. He's outrageous, boring, and rude. He pretends to be a leader and a change agent. He pretends that he's your friend. He is sly, cunning, and deceptive. He dresses, acts, and speaks like a slob. He's informal and terminally unique. He is childish and pretends that he knows nothing. He has no conscience and pretends that might makes right and that the ends justify the means. He's impulsive and rationalizes his behavior. He's deterministic, blaming others for his mistakes. He's skeptical, demanding that others solve his problems. His unreasonableness and irresponsibility make him a bad role model, bad father, brother, family member, friend, and a bad person, period. So if you think that you can be friends with a socialist, think again. Thank you. This is Ron, your host, the only true conservative in the United States today, bidding adios to the butchers, bakers, and candlestick makers out there, reminding you to be honest, to be smart, to be beautiful, and to remember that the left has no authority, no power, and they can't win.